Welcome to this lecture on negotiable instruments. Today, we are going to explore a fascinating area of commercial law, looking at how private documents can function almost like money. In our economic system, we usually use money issued by a central bank to pay for things, but there are alternatives. A negotiable instrument is a physical document created by private parties that entitles the holder to money. Legal scholar Sussman called it a kind of private currency, and Professor Good described it perfectly as a document of title to money. Let us look at a common example, the check. Even though a check itself is not cash, presenting it to a bank entitles you to obtain money. The person who issues it, known as the drawer, specifies the exact amount and the specific person to be paid, known as the payee, and then signs the document to make it valid. How does the law define this? According to Section 3104 of the Uniform Commercial Code, it is an unconditional promise or order to pay a fixed amount of money. Scholars Seeley and Hooley add that it physically embodies a payment obligation, meaning whoever possesses the document is presumed to have the right to claim the money it represents. The word negotiable basically means transferable, but in law it has two distinct characteristics, as noted by legal scholar Barak. First, the instrument can be transferred from one person to another, transferring the rights along with it. Second, and most importantly, the person receiving the instrument might actually acquire a better legal title to it than the person who transferred it to them. Let us break down that second point with an illustration. Imagine Sam steals a promissory note from Sarum. Sam then transfers this note to Michael, who accepts it in good faith, completely unaware it was stolen. Under normal property laws, Michael would have no rights. But because this is a negotiable instrument, Michael acquires it free from equities. This means Michael gets a perfectly valid title and can claim the money from Sarum, even though Sam's title was defective. You might wonder why the law allows this. It is to promote commerce. By treating these documents as free from prior defects or equities, people can accept them with confidence. It makes the negotiable instrument as liquid and reliable as physical cash. If a business accepts cash, they do not worry if a previous owner stole it. Negotiable instruments are treated with that same level of commercial trust. Conversely, if a document is marked non-negotiable, this special protection disappears. In the case of Wilson and Meeson versus Pickering, a clerk was given a blank check explicitly marked non-negotiable. She fraudulently filled it out to pay off her own debt to a third party. Because it was non-negotiable, the court ruled that the third party could not acquire a better title than the fraudulent clerk, and they were ordered to return the money. So what exactly must a document look like to qualify for these special rules? Under the Uniform Commercial Code, it must meet 4 strict criteria. It must be signed by the creator. It must contain an unconditional promise or order to pay a specific, certain sum of money. It must be payable either on demand or at a very specific future time. And finally, it must be payable to order or to the bearer of the document. There are several types of negotiable instruments used in the financial world. The most common are checks, which order a bank to pay money. There are also bills of exchange, which are orders between parties to pay at a future date, and promissory notes, which are direct written promises to pay. Other examples include treasury bills, banker's drafts, and even standard banknotes. To wrap up, remember that negotiable instruments are essentially private currency. Their defining feature is their negotiability, the fact that they can be transferred freely, and that an innocent purchaser can acquire a perfect title even if a previous owner had a defective one. This unique legal mechanism is what allows these documents to drive modern commerce.